Hi everyone, my name is Shazia Khan and the unit we'll be doing today is contract law. And we'll be looking at learning outcome 5, 6 and 7 today. So before I go on to doing learning outcome 5, I'm going to give you a brief summary of what we did in learning outcome 4, which was to understand the legal issues of misrepresentation and mistake. So we looked at when misrepresentation occurs, and it's when one party provides misleading information that influences the other party decision-making process, causing them to enter into a contract they would not have otherwise agreed. We looked at the remedies for misrepresentation, which was rescission and damages. We looked at the different types of misrepresentation with reference to case law. So we looked at fraudulent misrepresentation. We looked at negligent misrepresentation with reference to cases such as Shani Ford Supplies and Edge. We also looked at innocent misrepresentation, and we looked at 4.2, which was to differentiate the types of misrepresentation. So again, we referred more to innocent, fraudulent, and we looked at negligent as well. We looked at cases such as With and Flanagan, 1936. We looked at Banks and Cox, and we looked at cases such a very famous case for negligent misrepresentation is Headley Bryan and Co. Limited and Heller Partners Limited, 1964. We also looked at negligent misrepresentation and looked at the case of Howard Marine and Dredging. We looked at 4.3, which was to look at the categories of mistake, and we looked at the law of mistake and how it refers to where both parties have entered a contract under the same fundamental mistake, which will render the contract void. We looked at the types of mistakes. So you have common mistake, and we looked at the case of Cotier and Hasty, 1856. And Galloway and Galloway, 1914, and the case of Bell and Lever Brothers Limited, 1932, which looked at common mistake. We also looked at mutual agreement mistake, where an agreement is mistake in one in which a fundamental mistake has been made relating to the terms of the contract. We looked at the case of Raffles and Wichos, 1864. We also looked at Smith and Hughes, another famous case in regards to purchasing some oats. We went on to look at the doctrine of fault in mutual agreements. We looked at unilateral mistake, where this form of mistake applies when one of the parties to the contract is mistaken as to the part of the contract. And we looked at the case of Hartog and Collins and Shields, 1939. And we looked at the case of Shui in regards to unilateral mistake. And we then went on to look at a famous case of Lewis and Avery in regards to unilateral mistake. And then we identified what the court rulings were in regards to unilateral mistake. So we looked at mistake and misrepresentation in learning outcome 4. Now we're looking at learning outcome 5, and we'll be looking at 6 and 7 as well together. So in learning outcome 5, we look at understanding the legal issue of frustration. So the learning outcomes here was to summarise the different ways in which a contract can be frustrated, providing examples of each. So 5.1 summarise the different ways in which a contract can be frustrated, providing examples of each. So frustrated contract, firstly. A frustrated contract is a contract that's subsequent to its formation and without fault of either party is incapable of being performed due to an unforeseen event or events, resulting in the obligations under the contract being radically different from those contemplated by the parties to the contract. the legal consequences of a contract which is found to have frustrated is that the contract is automatically terminated at the point of the frustration. The contract is not void ab initio from the beginning, only future obligations are discharged. At common law, obligations which fell due to the performance before the frustrating event are still in operating. So the doctrine of frustration discharges both parties from their contractual obligations, where following the formation of the contract, performance of the contractual obligations become either impossible or radically different. So we mentioned in regards to that, in regards to how the contract becomes void. When will a contract be frustrated? So delay can lead to the discharge of a contract, as I've mentioned, where a commercial purpose of contract has been frustrated. Further, commercial parties will not be expected to wait until the end of a long delay to find out whether, in fact, they are bound by the contract or not. A party to a commercial contract is entitled to act on reasonable commercial probabilities and may treat a contract as discharged where an event has caused a delay even before the delay actually frustrates the contract. Essentially, what the doctrine of frustration allows for a remedy in case of a change of circumstances. This does not seem contradictory to the law of contract and contractual freedom. The law allows, if the law does not project a party from a bad bargain, why does frustration protect against unfortunate one? And the doctrine of frustration was formed in the case of Paradigm Jane 1647, where it ruled that the irrelevant changes in circumstances parties could never be freed from their contractual obligations. Difficulty establishing a frustrated contract. Establishing frustration can be difficult as it does not apply to hardship. Hardship, even if severe, does not constitute frustration. The fact that method of performance contemplated by a contract has been affected or burden of the performance has been increased by an event or events occurring without fault does not amount to frustration unless performance in accordance with the contract has become commercially impossible. For a party to succeed in claiming frustration, they must show that in the relevant contract, the parties have never agreed to be bound in the fundamentally different situation that had unexpectedly emerged. Understanding the justification for the doctrine of frustration, it's really important to give you a basic example. Okay, so if I paid £50,000 for a meet and greet with a famous celebrity, and before the meet and greet, the celebrity died, would it be fair that I would still be forced to pay the £50,000? The doctrine of frustration would intervene at this point. Of course, this is a very basic example, and things can be a lot more complicated than this. When assessing, so events leading to a frustrated contract, so the destruction of the subject matter, so occurring after the formation of a contract, complete the destruction unnecessary, Taylor and Caldwell case, personal services, supervening incapacity, so if the performance is envisaged, sorry, the first one is destruction, and the case that we could look at in regards to that, which I'll give you a little bit on, is the case of Taylor and Caldwell. In this case, the claimant hired out a music hall in Surrey for the purpose of holding 4 grand concerts. The claimant went to great expense and effort in organising the concerts. However, a week before the first concert was due to take place, the music hall was destroyed by an accidental fire. The claimant sought to bring an action for breach of contract for failing to provide the hall and claim damages for expenses incurred. It was held that the claimant's action for breach of contract failed. The contract had been frustrated as the fire meant the contract was impossible to perform. The next one is personal services supervening incapacity. If the performance is envisaged by a specified individual and no substitute is likely to be satisfactory and the contract will be frustrated. And that case of that would be the case of Condor and Baron Knights, 1966. In this case, a 16-year-old agreed by contract to play the drums for the defendant band for 7 nights per week for 5 years. The claimant suffered a mental breakdown and was told by his doctors that he should not perform more than 4 nights per week. The band dismissed him. He brought a claim for wrongful dismissal. It was held in court that the claimant's action was unsuccessful as his medical condition made it impossible for him to perform his contractual obligations, and the contract was thus frustrated. Another one in regards to strikes is Pioneer Shipping Limited. And then effects of the war, Finlet AG Veneva. And then we've got the non-reoccurrence of an event, which is where an agreement is dependent on the event taking place. The cancellation of that event may lead to the contract being frustrated if the whole purpose of the contract has been lost. And the case in regards to that is Krell and Henry, 1903. In this case, the defendant hired a flat on Pall Mall for the sole purpose of viewing King Edward's VII coronation procession. The price agreed was £75 for 2 days. The defendant paid £25 deposit. Due to illness of the king and the coronation was cancelled. Consequently, the defendant did not use the flat. The claimant sought the claim the outstanding £50. It was held that the contract was frustrated as cancellation of the precision deprived it of its commercial purpose. The claimant's action for breach of contract was thus unsuccessful. The other one is the case of may not, however, the contract must be deprived of the whole commercial purpose to amount for frustration. And that was the case of Herne Bay Steamboat and Hutton, 1903. In this case, the defendant hired out the claimant's steam ship. The purpose of the contract was to take paying passengers to view the naval review, which was part of the King Edward VII's coronation celebration. The defendants was also offering a day's cruise for the passengers. The naval review was cancelled as the king was ill. The defendant did not use the steamship and the claimant brought an action for the agreed contract price. The defendant argued the contract had become frustrated due to the cancellation of the naval review. It was held in court that the contract was not frustrated. The contract had not been deprived of its sole commercial purpose as it was still possible to perform the day's cruise. The naval review was not the only commercial purpose of the contract. So yeah, in that instance, the contract was not frustrated. So if the contract has been rendered more difficult or expensive, this does not itself lead to frustration. And then government intervention as well, which is where a declaration of war turns out the parties into an enemy line, or where the government requisitions in the use of property, a contract can be frustrated, and that's the case of Metropolitan Water Board and Dick Care, 1918. And the case of if a contract's been rendered is the case of Tassacoria and Limited and Nobly Thori. In this case, 1962. The defendant agreed to ship some Sudanese peanuts during November to December 1956 to Hamburg for certain price. On the 2nd of November, the Suez Canal was closed to shipping. The defendant could still have transported the peanuts within the contractually agreed time, but this would mean going by the Cape of Good Hope, which would take 4 times as long and increase the cost of transport considerably. The defendant did not carry the goods and argued the contract had been frustrated. It was held in this case that the contract was not frustrated. It was still possible to perform the contract without any damage to the peanuts. The fact that it was more difficult or costly to perform is not sufficient to amount to frustration. So this is in regards to the references we've used for frustration. So the effects of frustration is that where a contract is found to be frustrated, both parties are released from their obligations under the contract, and neither party can sue for the breach. So, it identifies that if they are both responsible, they would be liable for that. So these references have been used for this session on frustration, and we're going to move on. This is learning outcome 4. Now we're going to move on to learning outcome 5. 6, sorry, this is learning outcome 5. We're going to move on to learning outcome 6. I'll just share the slides with you. So in learning outcome 5, we looked at the law related to frustration and how a contract can be frustrated, and referred to the elements of frustration and why it's so important in regards to contract law and when a contract can be frustrated. Now we're going to look at learning outcome 6, which is to understand the legal issues of duress and undue influence. So the learning outcomes is to explain the concept of duress and undue influence. So 6.1 is to explain the concept of duress and undue influence. So duress and undue influence. So the doctrine of duress and undue influence, these doctrines have both provides a means for an individual to avoid an already concluded contract. So this is an example where you have been forced under duress to sign a will, or else I'll do this to you. So these are doctrines operate where an individual has been forced or coerced into a contract by threats, maybe by unfair pressures, or unreasonable influence. So it could be a child for an older child forcing the elderly parent to sign the contract, because of the vulnerability issues. The justification of these doctrine is fairly obvious. It is that it prevents one party taking unfair advantage of another. The effect of these doctrines on a contract is that it makes the contract voidable at the request of the aggrieved party. So duress. So duress is when a person is forced to do something against his or her will, that a person is said to have been the victim of duress, compulsion. In the context of contract law, this refers to where a party uses duress against the other party in order for them to enter into a contract which they either do not want to, or where the terms of the contract are unfavourable to them. A contract induced by physical violence is void. Duress by threat of violence. If a party is able to prove that they have coerced into a contract due to threat of violence, the contract can be voidable. There are two main requirements of duress by threat of violence. The nature of the threat must be sufficient to amount to duress, and the effect of the threat must have been that it forced the claimant into the contract. An example of duress would be physical abuse by an abuser. X hitting the victim until they gave the abuser valuable jewelry. Proving undue influence is more complicated. An example of undue influence would be an abusive spouse to withhold affection unless the abusive spouse were given valuable jewelry. So looking at the nature of threat, duress by nature of threat is that the threat must be sufficient in its nature to amount to duress. Usually the indicator the courts have used is whether the threat is illegal. And if the threat is illegal, there's a presumption that this will amount to sufficient threat. The illegal act in question must be a criminal act as opposed to one of a tortious nature. The case of Barton and Armstrong 1976 is an authority for this point in regards to illegal act. In this case, a threat of murder was one amount to an illegal act of sufficient nature. The next one is the effect of threat. So the distinction to make when ascertaining the effect of threat is whether there is a threat which results in a claimant voluntarily entering the contract, or whether the claimant involuntarily entered the contract. And the case in regards to that is the case of, it's a criminal law case in the case of Northern Ireland and Lynch, 1975, a criminal case which provides an effective explanation of this. The judges accepted that even in extreme circumstances in this case, there's always usually an option, but it must be the only one option is realistically available. In contract law, there has been unwillingness to accept the position in the case of the Northern Ireland and Lynch. It has been suggested that the claimants must be overborne, and he must have had no choice. However, if you examine the case of Barton and Armstrong, surely despite the threat of murder was still alone a choice overall, it can be concluded that threat must be one which is illegal. Economic duress. So the doctrine of economic duress was established in the case of Poe on Long 1980. And Lord Scarman set out two requirements in this case, which was cohesion of the will that vitiates consent, and the pressure of threat must be legitimate. In this case, the plaintiffs, P, owned the shares of a private company which owned a building that defendants D wanted to buy. The defendants were majority shareholders in a public company. P agreed to sell their shares in private company to D so that D could acquire the building. In return, P would get shares in the public company. Fearing a drop in the share value of public company would result, P and D made another agreement that P would not sell their shares for a while. However, P realized that D might profit from this agreement and demanded that the second agreement be replaced with one in which P was indemnified for any fall in share value, but might also benefit from any rise in share value. Fearing that not agreeing to this would delay the main contract, D agreed. The share value did drop, and P sought to rely on indemnity contract. D refused to comply with this, and the case reached the Privy Council. The issue in the Poe case was that the defendants claimed that the consideration for indemnity agreement was past consideration and only being agreed to under duress, and the court found for the plaintiffs, applying the exception to the doctrine of past community consideration in Lamley and Braithwaite, 1615. Lord Scarman said that an act done before a promise was made was good consideration for that promise if it was done at the promisee's request, and the parties understand the act was to be paid for at a later date, and the payment of the benefit would have enforced had it been promised in advance. The first requirement that requires a cohesion of the will that vitiates the consent was highly criticised by academics such as ATHE. It was criticised in the case of Dimshock Shipping Company in 1991, where they just criticised the cohesion of the will that vitiates consent requirement on the ground that a victim of duress consent has not been vitiated, as they're completely aware of what they are doing and they consent intentionally. The lack of practical choice, practical example of this principle in operation can be found in B&S Contracts and Design Limited, Invicta Green Publications Limited, 1984. In this case, there was a contract to erect some exhibition stands. A week before the due date of the contract, the builders refused to work unless they were paid more money. If the claimant had not paid the extra money, they would have suffered serious loss as a result of the contract they had involving completed exhibition stands. In this case, they had no realistic option but to pay the extra money to avoid serious losses. If we look at DRS, can it be lawful? It was established in CTN Cash and Carry Limited and Gallagher 1994 that duress may be lawful under certain circumstances, despite the unreasonableness of the demands. In this case, the CTN contracted with Gallagher for some goods. Unfortunately, CTN delivered the goods to the wrong place of business. Gallagher attempted to remedy this, but the goods were stolen before they could do so. GTN mistakenly believed the goods were at risk of Gallagher, and the courts held that there was no duress in this case. So undue influence, the next one to look at is undue influence is defined as unfair persuasion. It is a milder form of duress than physical harm or threats. It occurs when the victim is under domination of the persuader, or is one who, in view of the relationship between them, is warranted in believing that the persuader will act in a manner detrimental to the victim's welfare if the victim fails to assent. It is the improper use of trust to power to deprive a person of free will and substitute instead another's objective. Usually the fact pattern involves the victim being isolated from receiving advice except from the persuader. So there are some examples of undue influence. So a child takes advantage of an infirm parent. A doctor takes advantage of a parent of an ill patient. A lawyer takes advantage of an unknowledgeable client. And if there has been undue influence, the contract is voidable by the party who has been unfairly persuaded. Just before we finish off with undue influence, there are the types of undue influence identified. Two distinct classes of undue influence: actual undue influence and presumed undue influence, which can be categorized as protected relationships or other relationships. And the famous case in regards to this was the case of Barclays Bank PLC against O'Brien, 1994. In this case, there was fraud, misrepresentation, mortgage, and a married couple. The defendants were a married couple who took out a second mortgage on their home as security for overdraft facilities extended by Barclays to the husband's company. The wife had no interest in the business. Before execution, the branch manager advised the couple to seek legal advice prior to signing the documents. The wife eventually signed the documents, relying solely on her husband's false representation that the deed was limited to £60,000 and would last 3 weeks only. In the end, the husband's company reached 154,000 overdraft, as a result of which Barclays sought an order for possession of the mortgage security, for i.e. the company's house. The wife appealed, as the issue in this case was the wife's appeal was dismissed for lack of evidence her husband's misrepresentation. The Court of Appeal then allowed her appeal based on special protection she was owed in equity. It was held that the mortgage was only enforceable against her to the extent of £60,000, the amount she believed the mortgage was for. The decision in this case was that the House of Lords found in favour of the wife, as well, albeit not on the basis of special equitable protection. The court held that the husband exercised undue influence, misrepresented the deed, committed a legal wrong, and thus induced her to sign the deed. As a result, the wife had equity against her husband to set the deed aside. Such equity was enforceable against the third party which had constructive or actual notice of the situation that gave rise to the equity for whom the husband was an agent. Barclays, in this case, the creditor would have constructive notice when the transaction in question was not to the wife's financial advantage and which carried a significant risk of the husband's committing a wrong in law or equity. The next one is actual influence. So the class of undue influence can be seen as alternative manifestation of duress being conceptually similar. Actual undue influence has been described as the acts of improper pressure or coercion, as we mentioned earlier, in regards to the coercion in regards to draw a parallel element of threat. case in regards to that is the CIBC Mortgages PLC and Pitt 1994. In this case, Pitt wanted to purchase some shares. In order to fund this purchase, he put pressure on his wife to sign a second mortgage over the family home. The application for the loan stated the purpose was to purchase a holiday home and pay off the existing mortgage. Following, the husband used the money to purchase the shares. When the bank sought to enforce their security under the mortgage, the wife attempted to claim undue influence against her husband. It was held that there was no requirement to demonstrate manifest disadvantage where actual undue influence was established. Therefore, there could be a claim for actual undue influence. Unfortunately, due to other issues relating to the notice of the bank, the claim failed, but the principle of no requirement manifest disadvantage remains for presumed undue influence. So we've looked at undue influence and duress with reference to examples of case law and relevance of these cases, and how they apply to different elements of undue influence and duress. These are the references we've used for learning outcome 6, and we've finished learning outcome 6 now, and we'll be moving on to learning outcome 7. So I'll just share the slides with you for that. So this is the final learning outcome in regards to elements of a contract, and we've looked at learning outcome 5 and 6, and now we're looking at learning outcome 7, which is to understand the legal issue of damages and the importance of this. So the learning outcome is to explain the concept of the remoteness and measurement of damages. So damages in contract. Damages are awarded for breach of contract. Generally, the purpose of an award of damages for breach of contracts is to compensate the injured party. The general rule is that damages are meant to place the claimant in the same position as if a contract had been performed. Damages are usually awarded for expectation loss or loss of a bargain or reliance loss, wasted expenditure. In some cases, the court may award damages which go beyond a strict measure of compensation. As we mentioned, damages are awarded in regards of money to compensate the innocent party. The primary purpose of damages in contract law is to place the injured party in the position they would have been if the contract was performed, as we mentioned earlier. Main case in regard to damages, which explained the basis of the remedy of damages, which was the case of Photo Production Limited and Securico Transport 1980, which looked at the basis of the remedy of damages. So there's the different types of damages, examples of non-compensatory damages, which are nominal damages, aggravated damages, restitutionary damages, an account of profits, damages for breach of damages for breach of are subject to the principle of remoteness, and causation and mitigation. So if we look at just looking at non-compensatory damages, are things like an award of sum of money, not only to compensate the claimant for his contractual losses, but also aim to compensate the claimant in relation to any bad conduct of other party. And then you've got compensatory damages, which are Damages are an award of sum of money which aims to compensate the claimant for his loss under the contract, and this need not be limited to loss from the contract itself. It may be compensate the innocent party for losses relating to subsequent contracts. And if you look at where a claimant has suffered a loss, the first step is to ascertain if the loss the claimant has suffered under the contract. And the general rule of to recover their own loss was in the case of Alfred McAlpine Construction Limited and Panato Limited 2001, where the claimant does not need to be able to identify an exact amount of loss. The fact is there's a loss at all, sufficiently to satisfy the first requirement. The courts attempt to quantify the loss no matter the difficulty. So it's really important that they identify that loss. The next element we're going to look at is remoteness. So the term remoteness, sorry, I'll just go back. The term remoteness refers to the legal test of causation, which is used when determining the types of loss caused by a breach of contract or duty, which may be compensated by a damages award. Causation refers to the inquiry as to whether the defendant's conduct has caused a harm or damage. Legal causation is different from factual causation, which raises the question whether the damage resulted from the breach of contract or duty. According to once factual causation is established, it is necessary to ask whether the law is prepared to attribute the damage to the particular breach, notwithstanding the factual causation. Damage which is too remote is not recoverable, even if there's a factual link between the breach of contract or duty of loss. In negligence claims, once the claimant has established that the defendant owes them a duty of care, it's the breach that the duty has caused damage. They must also demonstrate the damage was not too remote. Remoteness of damage must also be applied to claims under the Occupier's Liability Acts and also nuisance claims. Remoteness of damage is often viewed as an additional mechanism of controlling tortious liability. Not every loss will be recoverable in tort law. Originally, the defendant was liable for all losses which were direct consequences of the defendant's breach of duty. And a really important case in regards to remoteness is the case of Re Polymis and Furnace Withy and Company Limited, 1921. In this case, some stevedores carelessly dropped a plank of wood into the hold of a ship. The plank struck something as it was falling, which caused a spark. The spark was ignited by petrol vapors, resulting in the destruction of the ship. The arbitrator held the causing of the spark could not have been anticipated and therefore no liability arose. The claimant appealed and it was held that there was no requirement that the damage was foreseeable. The defendant was liable for all the direct consequences of their action. And this was overruled in a famous case called the Wagon Mound #1 case, 1961, which actually looked at the wagon mound being leaked of furnace oil. And the courts held that repoliness should no longer be regarded as good law, as the test of remoteness of damage was substituted for the direct consequence test. The next one we're going to look at is causation. So causation is a principle used in the assessment of damages for breach of contract or tort. Losses may have been foreseeable at the time of contracting or at the time of the breach of duty in the case of tort, but they will only be recoverable if those losses were caused by the breach of contract or duty. The claimant must prove on a balance of probabilities that the breach caused the loss. It is not sufficient for the breach merely to provide the opportunity or occasion for the claimant to injure himself. The so-called but-for test is used as a primary filter. If the loss would have happened in any event, the breach could not be said to have caused the loss. Causation is an overarching area of law which restricts the amount of that compensation in damages which may be recovered, which arises from a legal wrong. the person who is legally responsible for the loss caused by the defendant in a broken chain of causation. In the law of damages, there's marked distinction between causing damage in the colloquial sense and assigning responsibility for damage in law, as its core causation takes into consideration factors such as the legal duty breach, the facts of the case, past cases decided on balance of probability, future facts, and breaks in the chain of causation. The next element we'll be looking at is mitigation. So mitigation of damages is a contract law concept that requires that a victim in a contract dispute to minimize damages that the result from a breach of contract. This means that the victim is legally obligated to act in a manner that will mitigate both the effects of the breach and their own personal losses. So if a victim does not mitigate damages, the court may refuse to award any exorbitant damages that could have been reasonably avoided by the victim. The court will evaluate the victim's actions following the breach of contract to determine if they took steps that a reasonable person in a similar circumstances would have taken to minimize their losses. However, mitigation of damages does not require the victim to take extreme steps or make substantial sacrifices in order to avoid or minimize loss. So in contract law, mitigating damages will often involve making reasonable efforts, as we mentioned, to reduce losses resulting from the breach of a contract. An example of this is if a person is hired to perform a job and the hiring party actually cancels the contract in advance of the job, the hired party is generally expected to mitigate damages by seeking similar employment elsewhere if available. The duty to mitigate refers to a party's legal responsibility to make a reasonable effort to limit the harm or losses stemming from another party's wrongdoing or negligence. This duty can apply in a variety of legal contexts, including contract law, tort law, and employment law. The principle behind this duty is to prevent individuals from exacerbating a situation or doing something to prevent further damages, as we mentioned. That's simply passing all costs to the party to avoid cause the harm. For landlord and tenant situations, the duty to mitigate often does apply, but the specifics can depend on local laws. For example, if a tenant breaks their lease early, the landlord generally has a duty to mitigate damages by attempting to re-rent the unit. They can't just leave it vacant and then sue the tenant for remaining months of rent. However, if they make reasonable efforts to find a new tenant but are successful, the original tenant may still be liable in rent. The claimant duty to mitigate loss. The claimant is not permitted to allow their losses to mount up. They are under a duty to take reasonable steps to reduce it. And the case in regards to this was the case of Pearson and Saunders, 1919. In this case, by the terms of the contract, the defendant was to deliver goods to the claimant on a monthly basis, and the claimant was to pay for the goods within 1 month of the delivery. The contract was to run for 9 months, and the claimant received the goods at a discounted price because he had committed to purchase from supplier over the 9-month period. The claimant was late in making the first installment. This amounted to breach of warranty and not entitling the defendant to repudiate the contract. The defendant refused to continue with the original contract, but told the claimant that he would deliver the goods in future if the claimant paid cash on delivery, and would still let him have the goods at the discounted price. The claimant rejected this offer and purchased the goods elsewhere at a higher price. He then sued the defendant, claiming the difference between the contractually agreed price and what he actually paid for it. So in regards to this, it was held in the courts that the claimant was not entitled to damages. He was given the opportunity to purchase at the discounted price, but rejected this. He was under a duty to take reasonable steps to mitigate his loss, and the offer was a reasonable one, and one which the claimant would easily have complied with. There's some examples of mitigation of damages. So a mitigation clause in a contract outlines the parties' obligations to minimize losses in the event of a breach. Some examples are, for example, I'll give you a couple of examples. In an employment contract, if an employer terminates an employee without cause, the employee is usually expected to mitigate damages by seeking similar employment. If the employee finds a new job at a lower salary, the original employer might be liable for the difference. Another example is lease agreements, as we mentioned earlier about the tenancy. If a tenant breaks a lease early, the landlord is typically expected to mitigate damages by attempting to re-rent the property. If the landlord is unable to find a new tenant despite reasonable efforts, the original tenant may be responsible for the unpaid rent. Another example is a construction contract. So if a contractor fails to complete a project as agreed, the property owner may be required to mitigate damages by hiring a new contractor to complete the work. The original contractor may be liable for any additional costs in regards to that. Another example that we've got is supply contracts. So if a supplier fails to deliver goods as promised, the purchaser might be expected to mitigate damages by finding an alternative supplier. The original supplier could be liable for any differences. When we're looking at these scenarios, it could actually depend on the actual the case in advance. So, you know, each case is different in regards to it. But when it comes to damages in contract law, contractual damages are available through English law if one of the contracted parties have actually broken a term of the contract. Dependent on the contract itself, you know, we looked at the types of damages, compensatory damages. There could be also punitive damages which aim to punish the defendant for any sort of misconduct, and we looked at nominal damages, which acknowledges the claimants have breached without significant losses. And you know, damages in regards to would depend on the contract itself, the type of contract, because you know there are different types of damages for different types of cases. And it's normally a sum of money that is awarded to the party, and the purpose is that, you know, you are putting the injured person in the same position as they were before. So, you know, you need to take into account all the elements of the actual damage itself, you know, before any sort of damages is awarded. So we've finished the element of looking at damages within contract law. So we looked at Learning Outcome 7, which was to understand the legal issues of damages in contract law and how it's a legal remedy available to parties who have gone through any sort of elements of damages. We looked at compensatory damages and non-compensatory damages and what each element is. We also looked at the elements of remoteness, causation and mitigation with reference to cases and what each element meant. These are some of the, now we've finished Learning Outcome 7, so we've done Learning Outcome 7. These are the resources that have been used for Learning Outcome 7. So at the end of this session, we've looked at Learning Outcome 5, we've looked at Learning Outcome 6, and we've looked at Learning Outcome 7, and we've come to the end of Learning Outcome 7. The next session we'll be doing is the assignment discussion session for contract law. Please make sure you are going on to Moodle to get the resources and any sort of additional reading or any the recording of these videos so that you could look at when we're doing the assignment. And please make sure that you are going, if you have any questions, go on to learnerwork at ukvarsity.co.uk. Thank you for attending today's session.